Thursday, 3rd of March 2025, Abuja. The Election Petition Tribunal hearing for Edo State Governorship election petition for the National Judicial Institute (NJI) Abuja adjourned on Monday for judgment for dates where they go announce later under the tribunal seal and signature. The Justice Wilfred Bochi-led 3-member panel announced the final adjournment for the conclusion of written addresses by both petitioner and respondent for the petition, where they mark EPT/ED/GOV/02/2024, filed by the loser, Dr. Aswerime Ighodalo, and the political party, the People's Democratic Party (PDP), first and second petitioners. The Independent National Electoral Commission (INEC) are the first respondent, Governor Monday Upeulo are the second respondent, and the All Progressives Congress (APC) are the third respondent. For the resumed hearing, the petitioners plead under team of lawyers wey include Adetunji Oyeikpo, SAN, Ken Mozia, SAN, Abiodun Owonikoko, SAN, Rotimi Ogunesho, SAN, Larry Selekowe, SAN, A.T. Kende, SAN, A.K. Ajibade, SAN, Oluwole Iyamu, SAN, Oluseyi Jolawo, SAN, and others. Kanu Agbabi, SAN, A.M. Aliyu, SAN, E.M. Inuwa, SAN, Al-Hassan Umar, SAN, M.T. Abubakar, SAN, and others appear for the first respondent. Dr. Oyeyechi Ikpeazu, SAN, Chief Ofiong E. Ofiong, SAN, Festus Kayode, SAN, Tobechukwu Weke, Dr. Ike Chudi, Edward Ireluwe, Lydia Oluwakemi, Linda Chuba Ikpeazu, and others now appear for the second respondent. Emmanuel Ukala, SAN, E.C. Dewigwe, SAN, Chief Ferdinand Obi, SAN, J.O. Asoluka, SAN, Echezona Etiaba, SAN, Henry Bello, SAN, and others now appear for the third respondent, the APC. Like two hungry and angry boxers where they compete for Madison Square Garden and where they use every mistake where each other make, they slug each other for the world super heavyweight belt. Governor Upeulo lawyer can't reserve the best punch for the final minute of the fight before they knock out Mr. Ighodalo, who quickly disappear from the eyes of media for the tribunal premises immediately after the adjournment. Argument and counter-argument begin to fly immediately after the issue of extensive or verbose pages of the party address they resolved through formal withdrawal of all related filed motions. After that, Justice Bochi give 15 minutes each to the respondent and 30 minutes to the petitioners to present their written addresses. Agabi filed 12-point address, where almost take the wind out of the sail of Ighodalo and the PDP. For the first 2 points, the legal sage talk say, "Your Lordship no go fit annul the election because that one no be relief where they find. Your Lordship no go fit declare the petitioners as winners of the election on the ground say the argument they invalid." They also argue on the ground of non-compliance no dey accompanied by consequential relief. Also, Agabi argue say the number of polling unit agents Ighodalo and the PDP call as witness represents neglected number of polling units the petitioners challenge and the entire polling units for Edo State. Finally, say the witnesses not distinguish between wetin they hear and wetin they see. They fail to prove overvoting even as the petitioners dump rivers on the tribunal. The grounds not dey regular with one another and no dey consistent with themselves. I urge my Lordship to dismiss the petition, Agabi conclude. On the part, counsel to the second respondent, Ikpeazu, court also take Ighodalo to the cleaners with the argument. He talks in the petitioner mere academic exercise. Particularly, he can urge the tribunal make they dismiss the petition after he accused the petitioners say they tender sensitive material exhibits with missing parts, and he no tally with the serial numbers where he carry for identification, and tender Beaver's machine without say they open any of the machines to prove the allegation of overvoting. According to the APC counsel Ukala, to prove non-compliance of the majority vote, the Supreme Court can mandate say the petitioners must prove non-compliance from polling units to polling units, from ward to ward, and local government to local government. It contends say the petitioners just dump documents for the tribunal instead of them to prove after they call only 5 polling units out of the 4,000 for Edo State, and they call no single presiding officer for their hearsay evidence. They can also cite Ucha versus Elechi and Baba versus INEC. He say this one at the position of the law in spite of Section 137 of the Electoral Act. He then clear say the case of the petitioners no dey proven. So I urge my lordship may they dismiss the petition, Ukala conclude. To address for the petitioners, Mozia Contoc say they challenge 765 polling units and call only 5 polling units agents. He also talks say the petitioners disagree with the collation for ward and local government level. He begged me the tribunal for every way consider the petition for several grounds for cumulative effect. Say such ground when they take a loan no go get cumulative effect. And he talks say wetin they adopt where they academic no dey true. Moziako holds the disputed IREV result where the petitioners tender. He insists say no party mago the result. He also cites Austin versus INEC, Kennedy versus INEC, and Issa and another versus INEC and others before he conclude without any relief. We urge my lordship to grant this petition.
I mean, from the submissions of the INEC lawyer, the APC lawyer, and the governor's lawyer, it is very clear that the plaintiff, the complainant, as a matter of habit, they have to complain. Because I did the election petition with these same lawyers from the same chambers. All of those senior advocates. Yeah. Some of them were young lawyers when my case was handled, and they were involved in it. They know the truth. But it is he who alleged, who has to prove it. And I reminded them informally when the court adjourned. But in each unit you complain there is a problem, an eyewitness in that unit must be called upon to prove his statement on oath. Mm-hmm. So if you allege that there were 700, you have complaints over 700 units, and you also allege in the end you inform the court that you are going to tender or produce about 170 witnesses, and in the end you produce less than 20. Assuming without conceding that everything those witnesses says in respect of those specific branches were considered to them, you did not devote in those areas. As our counsel rightly said, it's like taking a bucket of water from the ocean. It doesn't affect the level. That is assuming that even the bucket contains water from the ocean. In their own case, the bucket is leaking. It can't take water. That is the summary of what I understand. And their response is to say, no, you can take a holistic view. Even not being a lawyer, you should know that the whole cannot be taken without the parts. It is the subtotal of the part that constitutes a holistic evaluation. So when the parts were not interrogated, the parts were not questioned, and as our lawyer rightly said, you just dump document. They know in my case that the court position is Every exhibit you dump, you must speak and read the exhibit in court, in the open court. It is not the judges to help you do your case. So I am very satisfied, not based on any other thing, but based on what the summary of what has transpired during the trial and the written addresses by all the counsels. I will sleep much better today, even though we must admit that it is only the tribunal and the tribunal alone that will determine the outcome.
The petitioners, which is the PDP, said they had motions. Motions. Also, the third respondent, which is APC, they said they have motions. But looking at it, they now decided that no, there's no point going to these applications because it will not be beneficial to any of these parties, and it will add to the burden of the judges. So what did they now do? They now decided to withdraw all the motions, and they went into the adoption of written addresses. And if you the respondents, you're talking about the INEC, the governor, and the APC, their adoption of addresses and adoptions were articulate and quite straight to the point. You see, this is a petition that we have already said it is dead on arrival. And now, you are saying we have 4,519 polling units in Edo State. You are challenging 765 polling units. That represents 16.7% of the total polling units. Out of these 765, we only called 5 polling unit agents. What happens to the 760 units? Dead. That is for that. They are in their own final submission of their written addresses. They now considered that 50 polling units that they suspected to be that they had about voting were actually cancelled at the polling units. And that is this unit that they were also asking the tribunal to nullify. You cannot put something on nothing and expect it to stand. It is not possible. And that is why we have told the public that APC, the governor, they are on the go. Nothing stopping them. We are aiming at victory, and we know come very soon that judgment will be declared. He who alleges must prove.
We had to adopt our final written addresses, and the court was gracious enough to grant counsels 15 minutes to add breaks. And all counsels were able to utilize their times. And for us, we were pleased as a petitioner that counsels were able to agree with us that the testimonies by witnesses were in consonance with our prayers, that there was overvoting in several polling units, and there was incorrect collation of scores in several polling units, and that INEC failed to submit herself to our own guidelines. So altogether, we petitioned 756 polling units out of the 4,000 plus polling units. And we were glad to state before the tribunal in our deliberations that in the cases of Kennedy versus INEC, in the cases of Baba versus INEC, and also Johnson versus INEC, the Supreme Court concluded that the percentage of witnesses brought before the court does not determine the overall outcome, as long as the witnesses were able to substantiate the evidence. So for us, we are pleased with the proceedings, and we are hopeful that very soon we will hear from the Secretary of the Tribunal the next date for the court's judgment.
E dey arguable if Ighodalo petition achieve enough to nullify one ward or local government council result, as against the entire election result, Governor Kwewulu, without any argument, win. My name na Rona Agbara, reporting for Oberland TV.